Hi, Darlene Morgan here with Morgan Law Group, estate planning and probate law firm. Another question that I get a lot is, can I do a probate myself? And the answer is maybe. For a very simple, straightforward probate, there are still a lot of technical requirements, and I'm going to kind of just give a little overview of what that process, or how to start the process, what that looks like. First off, after someone has passed away, if you would like to be the executor, or if you're named as the executor in the will, then what you're going to need to do is file a petition in the probate court. And that is what starts this probate process. Now, what we have here is a special form in California that the probate court is going to want to see. And it's called a petition for probate. It's on what's called a judicial counsel form, which you can find online. Now, it is a check the box kind of a form. However, it does require a lot of information on that form. It requires things like, of course, the name of the decedent, their date of death. The form wants to know about all potential beneficiaries, as well as their information, addresses. The form also is going to ask about values. So you're going to need to be able to list out all the values for real property, personal property. They also are going to want, or the form asks for information about the decedent, where they died, that kind of thing. So there's a lot of initial information, and once that's filled out, the next thing is that needs to be served on all beneficiaries and heirs. After that, there will be a public notice requirement. So that's what you might have heard of called publication. And the probate code is going to list out what those notice requirements are. Then the court, once it receives that petition, is going to set a hearing date. Now, depending on what county you're in or how busy the court is, that can be 30 days, it can be 45 days. Sometimes they get backed up and it can be even longer. But the court will set an initial hearing on your petition for probate. At that hearing, the court will either accept or reject or deny the petition for probate, and naming the executor and that kind of thing. Now, prior to the hearing date, the court usually a few days, sometimes a week ahead of the hearing date, will publish some notes, oftentimes probate notes, letting you know if there's any deficiencies in the petition, so that you could potentially provide that information in advance to the court to supplement your petition. So once that hearing happens and the petition for probate is either accepted or denied, that's really where the process has now gotten started. That's where the executor actually receives legal authority to then proceed with the rest of the case. After they have what's called letters, the court issues letters, that's what it's called, giving the executor the legal authority to then collect the assets. They can then start assessing the creditors and the debts. So typically the executor is going to need to identify creditors, give them notice, and make sure that they handle whatever debts of the estate there are through the probate process. So as you can see, you can do it yourself. There are a lot of technical requirements, and once if mistakes are made, it just delays the process even longer. And of course, hiring an attorney is an option, especially if you're grieving the loss of a loved one. So please feel free to reach out. That's what our firm does, is we do help executors and family members navigate the probate process. So feel free to call us if we can be of help. Some of the things that a probate lawyer will do is really offer assistance to the executor in, like I said, navigating the court system. So some of the basics will include of probate, entering the will or lodging the will, making sure that the court needs to validate the will. The executor will also need to create an inventory of assets. The values of the assets will need to be determined. Create a list of debts that the decedent may have had, as well as then pay those debts through the probate process, and then finally disperse the assets to the beneficiaries. So that's kind of the high level overview. Now, if there's a will, that will usually make the process go a little easier because then the court can just typically approve what the will's already said. If there is no will, then that's what's called intestacy. And the court is going to be even more involved in who the executor may be choosing, who that person, especially if there's more than one person that would come forward to volunteer to be the executor, then the court will choose. The court also will have a say in the distribution, because without a will, the distribution will be according to the laws of the state of California. Now, not every estate will need a probate lawyer. There are occasions where you may be able to do it yourself, especially for a very simple probate or a very low value estate. Sometimes the assets may not even need to go through probate, depending on what they are and how legal title is held to the assets. Usually, though, if there are any assets to speak of, especially if there's any real estate, if there's multiple beneficiaries, or if you're planning on selling the real estate through a probate, then it would be helpful to have a probate lawyer to help make the process simpler and to go smoother and usually quicker, because they'll be able to guide the executor so that they follow all the rules. Which also leads me to an important point, that the executor does have a fiduciary duty to the estate. So what that means is that they do have a very high level of responsibility to follow all of the rules. Now, of course, there's a lot of rules that the executor may have no idea what they are. So that's where it can be really valuable to the executor to have that kind of help so that they don't miss any of the rules and then breach their fiduciary responsibility. Because if they do breach that fiduciary role, then they could be personally liable, depending on really what happened. So it is safer oftentimes for an executor, especially when there are multiple beneficiaries or any level of assets, to have the help of an attorney so that they make sure that they're complying with every rule, everything that's required of them under the probate code. The executor does get a fee for the work that they do, because there is that fiduciary role and there is a lot of work oftentimes to be done. And they also ask a lot of times what the probate lawyer's fee would be and when that gets paid. So the probate lawyer typically gets paid at the very end of the case through the assets of the estate. Now, there's oftentimes costs that need to be paid in advance. As the case goes along, there will be costs to file the petition. There'll be costs for the publication of the notice, as well as some of the probate referee costs. So there is costs along the way that need to be handled that can be reimbursed at the end. So some of the tasks that the probate lawyer will perform on behalf of the estate are things like filing the documents with the court, reviewing the information with the executor to make sure that they got everything correct. The probate attorney will actually be the one to coordinate publication of the legal notices in the newspapers. The probate attorney also will have interface with the creditors, or at least give guidance to the executor on what they need to know regarding the creditors and handling the debts. They're also going to guide the executor on making sure that taxes are paid, and that they make sure that they comply with all the rules regarding paying taxes. And really a good probate lawyer is going to keep current on the relevant laws so that the client, which is the executor, and the heirs will all have the comfort of knowing that the whole process is being handled smoothly, efficiently, and in compliance with all the probate court rules.